We're going to cover 5 general topics today. We're going to talk about the NLRB General Counsel. We're going to talk about the board itself. We're going to talk about proposed legislation on the Hill, the PRO Act, which is extraordinarily important. We're going to talk about the NLRB during the COVID era and a number of COVID guidance that the board has issued over the last several months. And finally, we will talk about the pendulum and what we expect to see happen with board decisions under the new administration. Let me begin with some general comments. I believe that if you want a litmus test of what employers will face during the Biden administration, look no further than the first few days at the NLRB. At a Labor Day event sponsored by the AFL-CIO, then candidate Biden said, quote, "If I have the honor of becoming your president, I'm going to be the strongest labor president you've ever had," close quote. He made good to that pledge. When you look at the makeup of the Biden administration's transition teams for the various administrative agencies, no less than 27 members were organized labor representatives. And President Biden has already delivered on that pledge to organized labor at the NLRB. So let's first talk about the NLRB General Counsel. Within the first 23 minutes following the inauguration, the White House wrote a letter to then NLRB General Counsel Peter Robb, a Trump appointee, demanding his resignation. When Robb refused, he was fired by 5 p.m. On the day of the inauguration. It strikes me that the White House should have had other issues more important than the NLRB's General Counsel during the first 23 minutes of the new administration. But I think that that is a measure of the influence that organized labor is going to have in this White House. The following, and by the way, no previous president had ever removed an NLRB General Counsel prior to the expiration of his term. And indeed, when President Trump took office, the Obama administration's General Counsel, Griffin, remained in office until his term expired months after the inauguration. The very next day, Peter Robb's number 2, Alice Stock, Deputy General Counsel, who automatically became the acting General Counsel, she was fired by the White House. And the following Monday, Peter Sung Orr, the regional director from the Chicago regional office of the NLRB, was named as the acting General Counsel. Mr. Orr is most famous for issuing a ruling in the Northwestern University football players case, finding that football players at Northwestern were employees for purposes of the National Labor Relations Act. Predictably, litigation followed almost immediately. The very next day, the first employer filed a challenge to the authority of the General Counsel's office to prosecute and issue unfair labor practice complaints. That case is H&M International Transportation, and we expect to see more litigation with employers challenging the ability of the board today to continue to prosecute unfair labor practice cases, arguing that because GC Robb was illegally removed from office, the GC's office is legally unable to move forward. So what does this mean? The GC drives the agenda of cases that are presented to the board for adjudication. Remember that shortly after he took office, General Counsel Robb issued a memorandum listing 24 decisions issued by the Obama administration NLRB that he wanted to present to a new Trump NLRB for reconsideration. I think we can expect acting General Counsel Orr to basically take the same memo, flip the names of the cases, and say that these are now cases to be resubmitted to a new Biden NLRB. And he's already taken steps, as Meredith is going to address in just a minute. More broadly, what can we expect? The Obama NLRB reversed 4,559 years of prior legal precedent. Expect the Biden NLRB to eventually overturn 15 minutes of Trump board precedent that reversed the Obama-era decisions and returned to prior NLRB substantive law. So a couple of practice pointers. The NLRB is on the verge of becoming an illegitimate agency because the substantive law is going to change so dramatically with each change in administrations at the White House. As a result, the opinions of the circuit courts of appeal are going to become more important as employers look for guidance as to what the governing legal principles are. And the second observation is for non-union employers, do not think that you will be unaffected by these significant changes. The non-union sector of the workplace is going to see a return of Obama-era law, which injected a sleepy old agency, the NLRB, designed to deal with union management relations, and injecting that agency and that law into the non-union workplace. As stated in the theme song of the terrific TV show Justified, for non-union employers, I see them long, hard times to come. Meredith, what has acting GC already done?
Steve, you're absolutely right, and as you can see from this slide, really wasted no time in making yet another statement as to where this agency is headed and where he views this agency as headed. On the 12th day of him assuming the acting general counsel role, he rescinded 10 general counsel memoranda that were issued by his predecessor, Peter Robb, and the day after rescinded yet another 2. And so the content of these general memoranda will come as no surprise to anyone. They address a variety of different topics. One is neutrality agreements. Another touches on union defenses in the context of duty of fair representation cases. And what we see with the rescissions is that there's going to be a shift toward more leniency in reviewing these kinds of issues, and certainly lowers union liability in the context of duty of fair representation cases. He also rescinded general memoranda addressing the Boeing case, which touches on employer handbook work rules. And we'll talk about that a little bit later in this presentation, but that was a pretty significant advancement in that space from the Trump era board. And I think although AGC Orr said that he didn't feel that the general memoranda was necessary anymore because the board had since interpreted Boeing, I think we can all read in between the lines and know that a return to the prior Lutheran heritage standard is underway, and that we will see increased scrutiny on employer work rules, in particular facially neutral work rules, which is a big deal for a lot of employers who were breathing a sigh of relief after the general counsel issued his memoranda in the Boeing decision, in taking comfort that some of their work rules, like civility rules, would not be under fire the way they had under the Obama era board. So we're seeing action already well underway at the board through acting general counsel Orr. And consistent with his wanting to take certain actions and really signal, I think, where he's going with the agency, we saw some news with respect to Scabby the Rat. So under General Counsel Peter Robb, Scabby the Rat was under threat. And former General Counsel Peter Robb really sought to limit the union's ability to use Scabby, in particular in the secondary boycott context. Now what we're seeing is, again, a shift back toward allowing unions to utilize banners and Scabby himself in connection with certain boycotts, and we expect a more lenient standard going forward in terms of what would be permitted with respect to unions utilizing these kinds of tactics in putting pressure not only on the target company, but also those with whom the company does business as well. Okay, so what's going on at the actual board? We talked a little bit about the General Counsel's office. As many of you know, the NLRB is a 5-member board. All of the members are appointed by the president, but they must be confirmed by a majority of the Senate. So right now, there is still a Republican majority of the board, but as you can see later this summer, when Bill Emanuel's seat is up, we will see President Biden have his opportunity to not only appoint another Democratic nominee to the board, but also to fill the vacancy that currently exists now. So we anticipate, regardless of what he does with the vacancy, that we will have a Democratic controlled NLRB toward the end of this year, perhaps even as soon as the fall, depending on how quickly he moves to appoint a new board member. Steve mentioned at the outset the PRO Act, and this is, again, I think one of those pieces of legislation that, if passed, would really bring sweeping changes to the labor landscape. This would significantly impact not only employers who are currently unionized, but in fact, in many respects, more significantly impact those who are not currently unionized. And it was already on February 4th, it was reintroduced in the House, and we anticipate it will be passed with no issue there. It remains to be seen what will happen in the Senate, but there's a decent chance that this legislation moves forward. And there's a lot of text on this slide, but I think some of the key takeaways here and the bottom line is that employers would see, again, a speed up in the time between the time of petition being filed and the election itself. So a return to the so-called quickie election, ambush election rules, which certainly favor the unions and not the employers. It would also expand the Act's coverage to a lot of independent contractors that are currently exempted from coverage under the Act because they do not fall within the definition of employee. And the way in which it does this is requiring and basically codifying the use of what we call the ABC test for independent contractors. And that is a very stringent test. In fact, it is the most stringent test that is used to evaluate whether or not an individual is an independent contractor or an employee. And it could result in potentially hundreds of thousands of contractors being now covered by the National Labor Relations Act, which not only opens the door for additional representation campaigns and to allow these individuals to unionize. So think gig economy and a lot of those companies, but it also opens the door for them to file unfair labor practice charges in connection with alleged terminations or cancellations of their contracts. So it could have an extremely profound effect on industries that have not typically been a target of unionization to date, and certainly give unions the opportunity to increase their presence in those spaces. It also, I think, one of the last points I'll make on the PRO Act before we move on, we honestly could spend a ton of time talking about this, but the last point you'll see on the slide is a really important point. And it's the introduction not only of additional penalties and damages in connection with certain kinds of violations of the National Labor Relations Act, but it also allows individuals to file a private right of action in court. And that is a completely new development and certainly would open the floodgates of litigation. In fact, we are already seeing non-unionized employees filing ULPs with the National Labor Relations Board challenging their terminations for as retaliatory for engaging in protected concerted activity, especially now in the era of COVID relating to raising health and safety concerns. So I think with the ability of these individuals not only to have a forum to go to the National Labor Relations Board, but also to file a private action in federal court, there's no doubt that we would see an increase in litigation on that front as well. So PRO Act is something definitely to keep tabs on, unionized, non-unionized employers alike, and frankly, employers of all sizes, because it really has the potential to be a game changer in this space. So if the Biden transition changes weren't enough for employers to focus on, we are still in the midst of a global pandemic, and COVID has no doubt impacted the way in which the board has conducted business over the past almost year. So we're going to talk a little bit about some of the announcements from the board, some of the actions the board has taken in light of the changes brought on by COVID, because it does impact a variety of the different components of the board, ranging from elections to ULPs on all different kinds of hearings. So we'll touch a little bit on that now. So the first topic we'll talk about is COVID and elections. So not surprisingly, here's the timeline and sequence of events. In March of last year, everything was suspended. People were reacting, the NLRB included, to the global pandemic and the shutdowns pretty much across the country. But over time, the NLRB had to adapt and things couldn't stay on hold for forever. And so this shows you kind of the timeline of what happened with respect to NLRB elections. And I think one of the biggest moves was to mail in ballot elections as opposed to conducting manual elections, which has always been the preference of the board and certainly is a preference of employers. There are a number of statistics out there that show that employers do not fare as well when there are mail-in ballot elections. So we are still in a period of uncertainty with respect to the pandemic. And so we anticipate that a number of these changes that were put in place by former General Counsel Peter Robb to remain, at least for the foreseeable future. So in addition to elections, there were also the underlying proceedings, and the NLRB took up a number of cases where there were challenges to the nature of the virtual proceedings and the teleconference proceedings and whether or not teleconference is appropriate or video conference is appropriate. And I think the long story short of it is that notwithstanding the fact that everybody agrees that there could be a detrimental impact to certain credibility determinations in the context of video conferences, that the reality is we are where we are, and that given the current circumstances, having conducting remote hearings is the best that the board can do at this point in time. So as I mentioned before, one of the significant evolutions at the board as a result of the pandemic is really the format of the elections. And the board in Aspirus noted the circumstances in which the mail-in ballot would be appropriate. And here are the different factors that are set out, which, makes sense. However, I think our experience to date has been that there are plenty of regional directors out there who are, notwithstanding these criteria and the decision in Aspirus, still requiring employers to utilize mail-in ballots even when these circumstances are absent. So that's not necessarily surprising, although it is certainly troubling for employers, especially employers who may have difficulty reaching the employees via a mail ballot election, and also considering a lot of the issues that typically come out of a mail ballot election, which in and of themselves can present quite a bit of headaches. So I'm going to turn it over to Steve to talk a little bit about what former GC Robb did with respect to elections and other COVID-related protocols at the board.
Thanks, Meredith. Interestingly, for all of the blistering criticism of GC Robb as being a management tool, when you look at the actions that the GC office has been taking with respect to COVID-related issues, I think you will see that he was still prosecuting employers for punishing employees for engaging in protected concerted activity. So, especially for non-union employers, let's go back and just for a moment talk about the basics. The NLRA does not just protect union activity, it protects any concerted activity. What activities are protected? Any that deal with terms and conditions of employment. And as you will see, terms and conditions of employment is not just wages, hours, and benefits. It is extraordinarily broad in its scope. And the statutory protection, though, is also for concerted activity. And concerted means either more than one, meaning two employees, or one employee who is clearly acting on behalf of others or is trying to engender support among others. So lots of employee activity, as Meredith has already mentioned, which occurs in a non-union workplace, is protected by the National Labor Relations Act. So what we have seen from the guidance that has been issued from the GC's office between May and November of last year is be ready for lots of unfair labor practice charges, even in non-union workplaces, where employees are claiming that they are being retaliated against for raising complaints and protests regarding COVID protocols and protections in the workplace. So September 18 of 2020, the GC issued a memo announcing a number of cases where complaint had issued and unfair labor practice proceedings are underway. On the issue of protected concerted activity, the first one at the top of page 12, in this case, a protest leader was discharged by his employer after he and a group of other workers came forward to protest their employer's alleged failure to provide PPE and enforce social distancing guidelines in the workplace. The GC found that that was protected concerted activity and that the issue of failure to provide PPE and social distancing dealt with terms and conditions of employment. In terms of bargaining obligations for unionized employers, one case involved a private school which was forced into remote learning protocols by state order. The GC found that the employer was not required to bargain with the teachers union over the state order. However, the GC advised that if changes were going to be made that were reasonably, two factors needed to be studied. Number one, were changes that the employer was seeking to unilaterally make reasonably related to the COVID-19 emergency? And number two, were the changes material, substantial, and significant? If those two factors are met, then a bargaining obligation is triggered even in the COVID pandemic. Mercy Health, a division of advice memo. Here, an acute care hospital was deemed to be lawfully permitted to unilaterally expand its work from home policy and to temporarily revise its attendance policy without bargaining with the union, so long as the actions were, again, reasonably related to the COVID emergency situation. So that will be the touchstone test for unionized employers looking to make unilateral changes. The Larry Peel case at the bottom of this slide, this goes to the issue of concerted. Here, two employees separately reached out to management to raise personal safety health concerns regarding COVID protections. In this case, the division of advice said the activities were not concerted. These were employees raising personal concerns in their individual capacity without any involvement of others or an intent to involve others. So that will be an important guidepost for employers going forward. However, as we will see later in the program, this definition of concerted activity is likely to change under a Biden NLRB. RS Electric, here the union contract provided the union with a right of access to the employer's premises, quote, at any reasonable time, close quote, but the employer imposed unilaterally a 1 hour advance notice requirement as a safety precaution. The division of advice found that that was not an unfair labor practice and that that was an action reasonably related to the COVID pandemic and was arguably permitted by the management rights clause under the union contract. Marrick Brothers Drywall and Hornell Gardens. In Marrick Brothers, an employee raised concerns regarding a lack of hand washing and hand sanitizing resources at a group safety meeting. Because he raised this in a group context, the GC found that he was engaged in protected concerted activity and his discharge was arguably unlawful. Hornell Gardens is the other side of the coin. Again, employees raising complaints about having to share isolation gowns or claiming that the employee had to self-quarantine and therefore could not work. The GC found that in those circumstances, those were individualized complaints being raised by the employees. All right, please confirm you're still listening. Midterm bargaining. Again, in these two cases, the collective bargaining agreement was in effect. It covered leave of absence and wage issues and included broad management rights clause. In those cases, the employers were not obligated to bargain over union proposals for enhanced paid sick leave or hazard pay, even in light of the pandemic. This is the MV Transportation case that Meredith's going to talk about in a bit, the contract coverage doctrine, where the Trump NLRB expanded employer ability to unilaterally act, but we will fearlessly predict that a Biden board will reverse that precedent. The Comcast cable case is similar. A management rights clause broadly permitted the employer to unilaterally implement a home garaging policy in order to reduce the number of staff coming on site during the pandemic. Children's school services, the employer was permitted under the layoff provisions and the management rights clause of the contract to unilaterally lay off employees in response to COVID-related school closures. And the GC also found that the broad management rights clause permitted the employer to offer temporary work assignments in lieu of layoffs without bargaining with the union in advance over those programs. And finally, Ballard, Spahr's personal friends at PASNAP, which is a nurses union in Pennsylvania. In this case, interestingly, Albert Einstein Hospital filed an unfair labor practice charge against the union, accusing the union of failing to bargain in good faith. The GC found no violation in this case because the initial delay in the start of collective bargaining was caused by pandemic-related pressures on the bargaining team, who were all nurses who were having to work extra hours due to the pandemic. So, Meredith, let's talk about our fearless predictions and what we see coming in terms of changes in the substantive law by way of decisions from the new NLRB.
Sure. So, not surprisingly, we expect the so-called pendulum to go back toward the Obama era type decisions. And we'll talk a little bit about some of the key areas that we're anticipating some changes, whether that be because there were some pretty landmark hallmark cases issued by the Obama era board, or because based on acting general counsel Orr's pronouncements to date, we anticipate a change in that particular space. So I guess the one easy thing about all of this is that you don't really have to look that far back in history to know where you're going next. And the first relates to workplace policies and handbook rules. And this is another area that applies to both unionized and non-unionized workforces alike in the exact same fashion. And what this particular slide gets at is the area of facially neutral policies. So we're not talking about policies that on their face chill or prohibit protected activity under the Act. We're talking about policies that are general policies, facially neutral policies, that may, either in application or in someone's perception, have the ability to potentially violate the Act. So one of the examples that was under fire in the Obama era in NLRB board was the so-called civility rules. So rules that required people to treat each other with respect, to say nice things about each other, to not disparage people. All of those rules, facially neutral rules, were called into question by the Obama era board. And in many instances, there were violations found because those rules could be viewed by the employee as reasonably chilling their right to engage in protected activity. So if someone felt like they couldn't disparage their supervisor, maybe they wouldn't raise complaints about their current working conditions. And as you can imagine, this created a bit of a minefield for employers when dealing with their handbooks and reasonable work rules, because many of them are facially neutral and in nearly all instances were not designed to chill activity, but instead are trying to encourage a harmonious work environment. So under the Trump era board, they issued a decision called Boeing Company, and this was also in connection with the General Counsel memoranda that Peter Robb issued that further clarified the board's position. And I think a lot of employers really did breathe this sigh of relief because it brought a sense of common sense and flexibility to the employer's ability to have reasonable work rules without worrying that a reasonable rule would be deemed violative of the National Labor Relations Act and create litigation and potentially penalties as a result of having those types of rules in place. Unfortunately, I think where we are headed is back toward the Lutheran Heritage Standard, which is a much more difficult standard for employers to actually implement in process. And I do think we're going to see a retraction toward a finding that more of those rules could potentially violate the act. And this could certainly lead, again, to not only additional unfair labor practice proceedings, but also additional litigation over handbook policies, which we somewhat happily had moved away from for a period of time, short period of time. So in addition to the workplace rules and handbooks, there's also, I think we can also expect a change going back to some of the prior precedent when we're talking about speech. Steve, can you touch a little bit on what we can expect in this space? I think it won't take long for people to realize there's a common theme throughout all of these slides.
Yes, absolutely. This is another area where particularly non-union employers were troubled by Obama-era decisions regarding the behavior of employees raising protected concerted activity concerns. Pier 60 is one of my favorite Obama-era cases. The facts in Pier 60 were 2 days before a union election, an employee posts on Facebook a commentary about his supervisor. The commentary was his supervisor is, quote, a nasty MRFer, close quote, a, quote, loser, close quote, and suggesting that everyone should F his mother and his entire effing family, closing with the admonition, vote yes for the union. The Pierce board said, this rose in the context of a union campaign. This was urging support for the union. You can't discipline the employee for using that comment and commentary. In Plaza Auto Centers, my second favorite case, here an employee is called into a meeting with the owner after raising issues about overtime pay. During the meeting, the employee gets upset. He calls the owner a, quote, effing effer, an effing crook, an a-hole, stupid, said nobody liked him, and if you fire me, you will regret it. The Obama NLRB said this arose in the context of a discussion over terms and conditions of employment. Therefore, it's protected activity. The Trump board in the General Motors case returned to a more even-handed approach. And what they said was that employers have a legitimate non-discriminatory interest in disciplining or discharging employees for abusive, profane, and or discriminatory behavior, even if it arises in the context of protected concerted activity. The board said that employers have obligations outside the NLRA under federal, state, and local anti-discrimination laws to protect employees and others against this type of behavior. And I think the Trump board accurately recognized that the Obama board viewed the world in such a myopic NLRB way that they forgot or ignored employers' broader legal obligations. Our prediction, expect a return to the law of Pier 60. And it'll be interesting, though, to see what the circuit courts of appeal do in these situations where employers are on the horns of a dilemma faced with abusive or profane employee conduct, albeit in the context of protected concerted activity. Another major decision of the Obama era was Purple Communications. As you may recall, that was the case dealing with employee use and access to the employer's email system. The Obama NLRB held that employees who are given access to employee email systems for work, which is everybody, has a statutory right under the NLRA to use those systems to communicate with coworkers for all statutorily protected purposes during non-working time, and that would include union organizing. The presumption, according to the Obama board, is that a law restricting access to an employer's email system is presumptively unlawful. The Trump board in the Caesars Entertainment case reversed that opinion, went back to prior board law, which said that a computer email system, an employer's technological platforms are akin to a telephone, a photocopy machine, a fax machine, and that an employer has a right to control the use of workplace equipment so long as they do so in an even-handed manner and do not enforce those rules, those facially neutral rules, in a disparate manner. Expect that Trump-era decision will go out the window in a Biden before a Biden board. Meredith, you want to talk about workplace investigations?
Sure. So in another area that was of particular importance to employers, we saw under the Obama era board, the decision in Banner, which really presented a lot of challenges for employers who are conducting workplace investigations and, not surprisingly, wanted to try and maintain confidentiality during those investigations. And what Banner did was really create a high burden on employers in order to be able to give those kinds of confidentiality instructions to witnesses during the course of the investigations. And essentially, what the board required employers to show was that there was a legitimate and substantial business justification that outweighs the rights of employees to exercise their Section 7 rights in connection with being able to speak freely about the terms and conditions of their employment. And from a practical standpoint, not only did that require the employer to come up with evidence that showed that there was a specific reason for it wanting to impose the confidentiality obligations, like the fact that they were worried about the destruction of evidence, of testimony being potentially altered, of a witness that was in need of protection. But logistically speaking, in order to get all of that evidence or to be able to know all of that information at the beginning of an investigation is nearly impossible. So by the time the employer may have a legitimate belief that it could satisfy this higher burden, any kind of confidentiality instruction, it would have been too late, because it would have already been halfway through the investigation, if not at the conclusion of the investigation, before the employer would have had the requisite information under the board's precedent to be able to impose those kinds of confidentiality instructions. So under the Trump era board in Apogee Retail, there was a welcome relief, again, from employers who are conducting these confidential workplace investigations, and again, took more of a common sense approach to the situation and found that that confidentiality instructions that are limited to the duration of the investigation are generally lawful. And in doing so, they recognize the important principle that a lot of these workplace investigations involve highly sensitive topics, and that there is good reason that has been litigated and confirmed by the Supreme Court, Circuit Courts of Appeals, et cetera, as to the importance of maintaining confidentiality through the course of these investigations, and that there's no reason why the National Labor Relations Act should somehow trump an employer's right to require confidentiality, at least for the course of the investigation. The board did stop short of saying that blanket confidentiality instructions that extend far beyond the investigation are lawful, and that the employer at that point in time would have been required to demonstrate some legitimate need for that continued confidentiality instruction. So unfortunately, I think consistent with what we've already talked about today, it would not be surprising to see a return to a less employer-friendly more employee-friendly precedent when it comes to workplace investigations, which could limit an employer's ability to provide those confidentiality instructions during the investigations. Now, a practical practice note, I will say that a number of employers have taken the position that they don't care what the board says, that this flip-flop is ridiculous, and they'll take their chances in court. And especially when you're talking about investigations of sexual harassment and things that are highly sensitive in nature, where the EEOC, another government agency, is encouraging confidentiality to protect victims of these kinds of incidents, there is a tension there. And a lot of employers are saying, I'll take my chances with the board. So from a practical standpoint, employers may have never changed their practices as a result of Banner. If they did, they got a sigh of relief under the Trump-era board. And I assume that many of them will continue to require confidentiality in the course of workplace investigations. And then whether or not that ultimately lands them in trouble under a Biden-era board will remain to be seen. I think, again, an important thing to note is the application of these principles is important too. And so this likely isn't going to present itself unless some kind of action is taken in connection with someone who breaches that confidentiality. And as is the case with any of potential violations of the NLRA, it's important to view any kind of adverse action with that in the back of your mind going forward. So shifting gears a bit to off-duty access to employer property, this is another area where we saw some changes underway with the Trump board. And again, not surprisingly, it was a shift from the Obama-era board, which allowed unions more free access to employer property and had a higher tolerance for certain kinds of activities being prohibited. And we saw a shift then in the Trump era board in Kroger, and there basically it was a finding that union activities are not similar to charitable, civic, and other commercial activities. So employers are free to permit those kinds of activities while at the same time excluding union activities. And that theme carries over into some of the other areas that we'll talk about today. So I think we can certainly expect a change back to a broader, more broad conclusion that civic, charitable, and other kinds of activities are similar to union activities, and therefore any kind of exclusion of union activities while allowing the other types of activities to take place on your property would be considered discriminatory. So stay tuned on that front. And similarly to the last slide, the same kind of logic applied involving a UPMC case where the employer wasn't required to open up its own public spaces to union activists or people who are engaging in union activities, even if it allowed other types of activities to occur in those spaces. So again, making it more difficult for unions to access certain areas of an employer's property. And I think, again, we can expect a return back to the prior precedent that allowed unions freer access, that allowed individuals freer access to public places at employers on employers' properties as we move forward. Okay. Protests. So again, along similar lines, the Trump board gave employers greater rights to exclude union activists. And it really changed sort of the burden on what the employer had to show in order to exclude union activity from its property. And so we saw, again, a shift away from the Obama era board. And I think we can anticipate a shift back to that precedent. And so I think employers need to keep in mind that whenever there are protests, whenever there are activities, whenever there are individuals on their property, regardless of where, I think that they can now expect greater scrutiny when they're seeking to exclude those kinds of individuals from the property, when they are trying to limit the kinds of activities that are occurring on that property as well. Okay. Work stoppages. So this was another interesting area where we saw development in the Trump board. So same employer, different years, different results. And I think this was pretty significant because, as many of you know, the NLRB certainly permits employees to strike. That's one of the fundamental rights under the Act. However, what is not protected is engaging in these intermittent work stoppages under certain conditions. And so what the Trump board did was really, I think, come down harder on employees who were engaged in a series of intermittent work stoppages and found that activity not to be protected, where there was clearly more lenience in viewing what constituted an intermittent work stoppage under the Obama era board. So there was a lot of criticism when this case came down, and I think certainly the fact that it involved Walmart, and Walmart was under pressure for a variety of other reasons, but I think we can all expect that a Biden board will likely return to the more lenient view of what actually constitutes an intermittent work stoppage, as opposed to the more lenient view that the Trump board had in finding that that the individual employees here had engaged in an unlawful intermittent work stoppage. And I will say that in the 2019 case, it involved for the most part, 4 work stoppages over a period of 13 months. So it was over quite a long period of time. It wasn't a significant number of work stoppages. So a lot of, in these cases, the facts certainly matter. But notwithstanding that, I still think that we can anticipate a more lenient view going forward of what constitutes a work stoppage versus not. Okay, Steve, I'll turn it over to you to talk a little bit about settlement standards, which is one of the favorites for a number of our employer clients.
Yeah, thanks, Meredith. And Meredith, I'm going to mention a question from the audience, and I'll comment, and you can chime in as well. Audience member asks, how do we see a return to Obama-era precedents in regards to workplace policies and bad behavior intersecting with diversity, equity, and inclusion initiatives? I think this is going to be one of the most interesting areas, because clearly you're going to have 3 Democratic nominees who I expect will be extraordinarily progressive in their view of employee rights, and how they deal with the Hobson's choice an employer faces in saying, well, you really can't enforce a respectful workplace behavior policy because that it might infringe protected concerted activity, when at the same time employers are needing to be very, very sensitive to DE&I issues. I think it's going to be very interesting to see what a progressive NLRB does in this area, and it's going to be a very, very tight needle to thread for employers. Meredith, what do you think?
I absolutely agree. I think that is a great question, and we got a lot of these questions in the wake of the Me Too movement as well. I think, as I mentioned before, I think there is a fundamental inherent tension between a lot of the former NLRB policies and employers' rights and, frankly, obligations in the Title VII space, in the DE&I space, to foster an environment that's free from behavior that could be violative of those other laws. So I think that we are definitely on a crash course, a collision course for those 2 areas, and employers have had to make that choice before. And like I said initially, when it came to workplace investigations, I know that most employers would fall on the side of, we don't care if we're going to face a ULP over this. We're firing this person who engaged in activity that violates our code of conduct, that violates our sexual harassment or discrimination policy, or that violates our values. And I think that we're going to continue to see employers taking that position. And so, as Steve mentioned, I think it'll be really interesting to see what a progressive board does with it. And a lot of this also highlights, I think, the kind of inherent inconsistency with some of the policy pronouncements here. I mean, we have Biden saying that the unions are the great equalizer of pay equity, when I think a lot of people who have experienced unionized environments have questioned whether unions have advocated fairly for women, treated women fairly. So I think there is a lot of inconsistency. And I think it will be very interesting to see how this all actually plays out, because especially at the higher levels, I think the NLRB is going to be hard pressed a progressive NLRB is going to be hard pressed to find that employers are engaging in unlawful conduct when you have these egregious cases of the violation of, DE&I standards and things that are, that employees are trained on in terms of respectful workplace and cultural competencies, et cetera. So it's a great question, and I think it'll be really interesting to see it play out.
All right, let me talk about settlement standards briefly. And it is more notable for what it shows in terms of an enforcement strategy than it is for the substantive law. Historically, at an unfair labor practice hearing, the administrative law judge had the authority to accept a settlement over the objection of the union and over the objection of the general counsel, if the judge thought it was a fair settlement. In the U.S. Postal Service, the Obama board reversed that and said that the administrative law judges could only accept a settlement offer over the objection of the other parties if it constituted a full remedy for all of the violations alleged in the complaint. Well, that's not settlement, that's capitulation. And there would be no reason why you would settle under those circumstances. In the UPMC Presbyterian Shadyside case, the Trump board went back to the old standards. Expect an aggressive enforcement approach by the new NLRB to return to the U.S. Postal Service standards. Meredith has already talked about independent contractor status within the context of the PRO Act. This is a very important topic, and important especially because the NLRB was the Obama administration's petri dish on independent contractor issues. In the FedEx home delivery case, the NLRB bravely rejected remands from the D.C. Circuit, not once but twice, saying that the D.C. Circuit was wrong in its analysis. Now, it is a brave NLRB attorney who has to return to the D.C. Circuit and say to the three judges on the panel sitting on the high dais, by the way, you guys and gals are all wrong because the NLRB says so. In any event, though, FedEx Home Delivery said that independent contractor status was dependent upon all of the pertinent common law agency principles, with no one factor being determinative, and the issue of entrepreneurial opportunity is no more important than any other factor. The board also said it would give weight to the actual exercise of independent contractor powers or opportunities, not the theoretical exercise. In Super Shuttle, the Trump board returned to prior precedent and adopted smartly the D.C. Circuit's rationale, saying that entrepreneurial opportunity is a central pillar. This independent contractor issue is going to be of crucial importance to employers across the full spectrum of state and federal employment laws. You're going to see it especially in FLSA misclassification lawsuits. So what the board has to say is pretty important. Meredith.
Thanks, Steve. So I'm going to keep an eye on the clock and try and make sure that we're able to hit through some of these other slides before running out of time. So I'll move through them relatively quickly. So another area that was a pretty big focus of the Obama era board was with respect to graduate student and particularly graduate student assistants, those who perform teaching or research duties in connection with their studies. I think a lot of universities have taken the position and did take the position in the wake of Columbia that these are primarily students, that these are students who are engaged in activities that are germane to their educational advancement, that are part and parcel of their educational curriculum, and that they are not traditional employees and should be excluded from that definition under the Act. The Columbia decision was a huge decision. It overturned the previous Brown decision in 2004. And so I think what we can anticipate is a new wave of graduate student unionization activity, because although the Trump board was involved in rulemaking with respect to whether or not not graduate students should be considered employees within the meaning of the NLRA. It did not finalize that rule. And so I think we can be certain it will not finalize that rule. And so we will be now back under we're under the Columbia University precedent. And I think we can continue to see now a kind of a resurgence in this space, and particularly with the pressures of the pandemic. I think it will be no surprise to a lot of universities to see a lot of the graduate student unions resurface with a lot more vigor than they have over the past several years. So in addition to graduate students, there was also rulemaking on joint employers. This is a really important area for a variety of companies, especially those that subcontract out certain portions of their workforce. A lot of companies use subcontractors or use contracting agencies, staffing agencies to supplement their workforce. You can call them contingent workers, temporary workers. Everybody has a different name from them, but this is a very big issue. The Trump board did pass a final rule that overturned Browning-Ferris, which really was again, another very low standard for determining whether or not two entities were considered joint employers under the act. So while there is a final rule in place, it will be a little bit more challenging for the Biden board to go back and revert to Browning-Ferris. However, I think that given the potential impact here, it would not be surprising if the board takes action to try and revert back to the prior standards. And as Steve mentioned, with respect to contractors, a lot of the joint employment cases really centered on the level of control. And so a lot of master services agreements reserve a level of control for the contracting company. And under the final rule, that was not enough to deem two entities joint employers. However, under Browning-Ferris, that, as well as some other facts, was sufficient to establish joint employer status. So again, another reversion, expect a potential reversion back to a lower standard for finding of joint employment status. However, this might take a little bit more effort and time to do so, given the fact that a final rule was passed. Steve, jurisdiction for religious institutions.
Yeah, I'm going to move quickly given the time, and I want to be sensitive to everyone's time. This is a fascinating theoretical issue, and it'll be very interesting to see what happens when these cases reach the Supreme Court, given its makeup, but I'm going to skip them. Appropriate bargaining units, as you recall, during the Obama administration in specialty healthcare, the board said that so-called micro units would be appropriate and that the unit petitioned for by the union would be presumptively appropriate unless the employer could show by way of overwhelming evidence that a larger bargaining unit was appropriate. In PCC structurals, the Trump board returned to traditional community of interest standards that have been pre-existing for decades. Expect that to be reversed. Rulemaking on the so-called quickie election rules, the Trump board addressed these piecemeal and did not get the job done before the clock ran out. They returned to some but not all of the previous representation case procedures, but you can expect that the Biden board will again go back to the Obama board's quickie or ambush election rules if given the opportunity. Meredith.
Thanks, Steve. So I'm going to kind of move through these relatively quickly. You already mentioned the duty to bargain with respect to unilateral changes, so I'll go through that. And I think maybe we should actually, given the time, we'll conclude with what's happening at Google, because I do think that this is important to note for both unionized, non-unionized employers, and for employers in sectors that traditionally have not had unionized environments. And I think what we're seeing at Google now is foreshadowing of what is to come. We're going to continue to see activism in the workplace, activism by what has been largely deemed to be white-collar jobs and in the tech space. So non-unionized employers in industries that aren't used to or haven't had unionized environments, I think need to pay attention. And for those of you that do have unionized environments, expect a lot more activity in that space and a lot more of your actions to come under potential scrutiny given the current climate and what we anticipate coming down the pike at the Biden board. Thank you all so much for joining us today. We appreciate it. A last plug, we now have a blog, and we are going to be posting posting continual updates on what the Biden transition means for employers across a variety of different topical areas, labor being just one of them. So please subscribe to hrlawwatch.com, and thank you all so much again. I hope you enjoy the rest of your days.